of a nation lies not in the mighty of its armies, important as that may be, not in the largeness of its economy, important as that may also be. The greatness of a nation lies in its fidelity to the Constitution and the strict adherence to the rule of law, and above all, the fear of God. The rule of law ensures that society is governed on the basis of the rules and not the mighty of force. It provides a framework for orderly and objective relations between citizens in a country. In Kenya, in the Kenyan context, this is underpinned in the Constitution. And as Surabaj, a former Attorney General of India, wrote, the rule of law is the heritage of all mankind, and a salutary reminder that wherever law ends, tyranny begins. Cast the rule of law to the dogs, and as Lawton once observed, the government becomes an euphemistic government of men. He adds, history has shown, sadly I might add, that even the best rulers have fallen prey to the cruel desires of naked power, and that reliance on the goodwill of politicians is often a risky act of good faith. End of the quote. The moment we ignore our Constitution that the Kenyans fought for decades, we lose it. We further note that elections world over are competitive features. Presidents in many parts of the world, and especially in Africa, wield a lot of power. The influence that comes with that office makes it very attractive. That influence cascades down through all the elective positions to the lowest. Candidates and political parties often do anything to be elected. Besides the candidates, the electorate themselves, hoping for an improved standard of living, get equally agitated. All these factors make elections at every level extremely high-pressure events. If these are mismanaged or candidates do not respect the rule of law, if the average citizen, political parties, and even candidates themselves do not perceive them as free and fair, elections can and have led to instability in some countries. Examples of such cases are abound, but we don't need to look far. We know what we went through in 2007, post-election skirmishes that left over 1,000 people dead and over 5,000 others displaced and drove the country almost to the brink of precipice, not to mention the economic crisis that was thereby wrought. In the circumstances, and in answer to the respondents' harp on the numbers, we can do no better than to quote the words of the Indian Court of Appeal, where the judge says, there is no denying the fact that the election of a successful candidate is not likely to be interfered with by the courts. The courts generally lean in favor of the returned candidate and place the onus of proof on the person challenging the end result of an electoral contest. That approach is more in the nature of a rule of practice than a rule of law, and should not be unduly stretched beyond a limit. We say so because while it is important to respect the popular verdict and the courts ought to be slow in upsetting the same, it is equally important to maintain the purity of the electoral process. An election which is vitiated by reason of corrupt practices, illegalities, and irregularities cannot obviously be recognized and respected as the decision of the majority of the electorate. The courts are, therefore, duty-bound to examine the allegations wherever the same are raised within the framework of the statute, without being unduly hyper-technical in its approach and without being oblivious to the ground realities. Experience has shown that electoral processes The electoral process is, despite several safeguards taken by the statutory authorities concerned, often vitiated by use of means, factors, and considerations that are specifically forbidden by the law. What of the argument that this court should not subvert the will of the people? This court is one of those to whom the sovereign power has been delegated under Article 1(3)(c) of the Constitution. All its power, including the invalidating of the presidential election, is not self-given nor forcibly taken, but is donated by the people of Kenya. To dishonestly exercise that delegated power and to close our eyes to the constitutional violations would be a dereliction of duty, and we refuse to accept the invitation to do so, however popular the invitation may seem. Therefore, however burdensome, but the majesty of the Constitution reverberates across the lengths and breadths of our motherland. Let it bubble from our rivers and oceans. Let it boomerang from our hills and mountains. Let it serenade our households from the treetops. Let it sprout from our institutions of learning. Let it toll from our sanctums of prayer. And to those we bear the responsibility of leadership, let it be a constant irritant. Have we, in executing our mandate, lowered the threshold for proof in presidential elections? Have we made it easy to overturn the popular will of the people? We do not think so. No election is perfect, and the technology is not perfect either. However, where there is a context in which two houses of parliament jointly prepare a technological roadmap for conduct of elections and insert a clear and simple technological process in Section 39(1)(c) of the Elections Act, with the sole aim of ensuring a verifiable transmission and a declaration of the result system, how can this court close its eyes to an obvious and near total negation of the transparent process? In keeping with our pronouncement regarding the burden and the standard of proof in election petitions, we are therefore satisfied that the petitioners have discharged the legal burden of proof as to squarely shift it to the first and second respondent. We are also of the firm view that having so shifted the burden has not in turn been discharged by the first and second respondents as to raise substantial doubt in regard to the petitioner's case. For the above reasons, let this judgment then be read in the proper context. The electoral system in Kenya today was designed to be simple and verifiable. Between the 8th of August 2017 and the 11th of August 2017, it cannot be said to have been so. The petition before us was, however, simple and to the point. It was obvious to us that IEBC misunderstood it, hence it jumbled up responses and submissions. Our judgment is also simple and, in our view, clear and understandable. It ought to lead IEBC to a soul searching and to go back to the drawing board. If not, this court, wherever called upon to adjudicate on a similar dispute, will reach the same decision if the anomalies remain the same, irrespective of who the aspirants may be. Consistency and fidelity to the Constitution is an unwavering commitment this court makes. One of the other peripheral but important matter requires our attention: the time frame for hearing and the determination of presidential election petition in Kenya. The court is able to bear all manner of criticism but one would be extremely unfair. Alleged inability to deliver on time. Where is the time? Between the decision in 2013 and the present petition, it was a matter of agreement across Kenya that 14 days is not enough for parties and the court to fully deliver on their respective mandates. Not because they cannot, in fact they all have, but because there may be the need to conduct exercises such as a recount of votes or a scrutiny which require substantial amount of time. Yet the legislature ignored pleas to rethink the time frame. It is time they did so. The reasons for doing so are obvious and need no extrapolation here. In concluding, we must express our profound gratitude to Council who appeared before us for their submissions that assisted us in reaching this decision. Before we read the final orders, I would now allow my colleagues to read their dissents. And I'm requested to start with Justice Ojwang.